good morning. Today myself and my teammates Fariza, Venchan, Haris and Reshmi will be critically evaluating the constant fluctuation of the locus standi over the years. So let's begin. So what is judicial review? So it represents the process by which the courts govern the exercise of a governmental power. Government departments, tribunals, state agencies, and agencies exercising their governmental power must perform their powers in a lawful manner. So prior to 1977, the rules on standing largely rely on the judges, and the rule was operated according to what remedy is being sought. Here the test establishes whether the person applying is a person who is aggrieved and not a mere busybody. After the year 1977, the rule of Supreme Court Order 53 Rule 3 subsection 7 and the Senior Court Act 1981 placed the sufficient interest test. So under section 31 of the Senior Court Act, it provided that unless it considered the applicant had sufficient interest in issues to which the application relates, the court must not permit permission for an application for judicial review. So the justification behind this to ensure that the administration makes decision to genuine cases of grievance and avoid unnecessary intentions, and especially intentions are not authentic. So the applicant may be an individual whose personal right and interest has been influenced by a decision. Also, it may be brought by a pressure group where the interest of the member's right has been affected. Here, Section 85 of the Criminal Justice and Court Act 2015 amended Section 31 of the Senior Court Act, where Section 31 subsection 2 subsection 2A states if it appears to the court that the outcome for an applicant would not have been significantly different if the complaint had not occurred, the court then must refuse relief on the application. Nevertheless, under Section 31 subsection 2 subsection 3C, such a requirement will take no notice by the court if there are reasons of exceptional public interest for doing so. Civil Procedure Rules 1998 states that within 3 months an action against the decision which the review is sought must be brought. However, statutes may be imply shorter time periods, and this must be complied with. Lord Phillips, in the case of R on the application of Abbasi, and Secretary of State for Foreign and Commonwealth Affairs 2002, states that decision involving foreign policy is a forbidden area and the court must not interfere with such cases. On top of that, it is less likely to be an appropriate matter for a judicial decision when it is a question more purely on politics, since the more appropriate approach would be through the political resolution. Contrarily, a court will obtain greater potential where there is a legal content of a particular issue, because it would be the function of court to resolve such questions. One of the questions that being asked frequently would be, can one stop court from implementing judicial review? And the answer would be yes, if it falls under the ouster clause. So in Animistic and Foreign Compensation Commission, House of Lords seems to demolish the difference between the error of law within the authority of the decision-making body, which had been regarded earlier as non-renewable, and errors of law had taken decision-maker outside its jurisdiction and were therefore become reviewable. If a sound decision has not been made, then the ouster clause does not have a standing, thus judicial review can be reviewable. Now I'm going to go on to speak when the sufficient interest test was issued was in the case of RN Inland Revenue Commissioners ex parte National Federation of Self-Employed and Small Businesses 1982. However, it confers the court a great deal of discretion as the judges are not mutual in their approach to the sufficient interest test. In RN Secretary of State for the Environment ex parte Rose State Trust Company Limited 1990, where Shkiman G cited a number of propositions which he deduced from the IRC case. So what are the facts of the case? Here a campaign group requested the secretary to prevent build works on the site of the historic Globe Theatre site in London. So the group then brought a judicial review claim against the decision not to designate the site when the Environment Secretary refused the group's plea. The issue was whether or not they had sufficient interest, and the High Court held that incorporation does not increase the standing, whereas if there is no individual member that has a standing, then the group will not have a standing as well. Although legal or financial interest is not required, not every person can enforce a public duty. The High Court set out guidelines where number 1, whether sufficient interest exists is not purely a matter within the discretion of the court. Number 2, it did not necessarily entail a direct financial or legal interest. Number 3, that the assertion of an interest by a person or a group does not mean that a sufficient interest exists. And number 4, even with thousands of people join together in a campaign that was not conclusive that sufficient interest existed, that the sufficient interest test has been established by individual, they can move on to the next stage, which is to establish the grounds for judicial review. In Council of Civil Service Union and Minister of State for Civil Service 1985, House of Law took the opportunity to offer a rationalization of the grounds for judicial review and ruled that basis for judicial review could be summed under three principles, namely illegality, irrationality, and procedural impropriety. Proportionality too can be said to emerge as a further ground for judicial review. Other than that, under the Human Rights Act 1998, judicial review seems to enter significant adaptations. Thank you.
I will be explaining the various interpretations of the sufficient interest test by courts over the years. As mentioned earlier, locus standi can not only apply to individual applicants but pressure groups as well. Determining locus standi for cases involving individuals can be fairly straightforward, as the applicant only needs to show that the decision that was made by local authorities are personally related to him, as seen in Crown and Independent Broadcasting Authority ex parte White House. In this case, the film that was broadcasted was considered to be controversial, and the court held that the applicant, who was a license holder, would be given standi. It was indicated that every television license holder, regardless if he is a viewer or not, would have locus standi on the matter. An example of a case involving a pressure group can be seen in Crown and Liverpool Corporation ex parte Liverpool Taxi Fleet Operators Operation. Here, the decision of the local authority to increase the number of taxi licenses was successfully challenged by a group of taxi owners. Although this case was held before the introduction of the sufficient interest test, it nevertheless had shown that locus standi would be given if the applicant, if he had been directly affected by the decision of the local authority. However, the real complications arise in situations whereby no members of the group that is applying for judicial review is affected by the decision made, as explained earlier in the case of ex parte Rose. So throughout the years, the word sufficient interest has been interpreted very generously by courts, and the start of this can be seen in Crown and Inland Revenue Commissioners ex parte National Federation of Self-Employed and Small Businesses, where the decision of the Inland Revenue to enter into an agreement with Fleet Street workers to levy tax was challenged by a pressure group known as the NFSE. The court held that the NFSE did not have sufficient interest on the matter to challenge the decisions of other groups entirely. Although the challenge had failed, it was important to note that Lord Diplock gave a dissenting judgment, expressly stating that this rule on standi is outdated and that a pressure group like the NFSE should have sufficient interest in cases where public authorities had acted unlawfully. This view was also shared by Lord Denning in the case of Crown and Greater London Council ex parte Blackburn, where he stated that a public-spirited citizen should be given standi in cases whereby public authority has made a decision that can be seen as transgressing the law. The courts then went on to a broader and liberal interpretation of the word sufficient interest, as seen in Crown and HM Inspectorate of Pollution ex parte Greenpeace. The plaintiffs in this case were an environmental pressure group that challenged the decision of the local authority to allow the opening of a nuclear processing plant, despite the issues of public health. The court allowed the judicial review as it was a matter of public interest. This case had shown that a pressure group could apply for judicial review as long as it's able to prove that the decision that was made was of the interest of some of all of its members. The courts then went even further, holding that sufficient interest could be found even in situations where none of its members are personally interested in the decision made. An example of this can be seen in Crown and Secretary of State for Foreign Affairs ex parte World Development Movement, where the Secretary of State had acted beyond its powers to allocate funds to the Pergawa Dam in Malaysia. The challenge was successful not only because it was a matter of public interest, but because it was also considered to be a group that is highly respected.
Now that we have taken a look at the manner in which the sufficient interest test has been introduced and interpreted by the courts, myself, Reshmi, will be going through the effect of the introduction of the Human Rights Act 1998 on the existing sufficient interest test established under the Seniors Courts Act 1981. Following the passing of the Human Rights Act 1998, which came into force in October 2000, it can be seen to have expanded the scope of judicial review by creating an independent ground for challenging decisions made by public bodies. It may therefore be possible to challenge a decision on the basis that it infringes one's human rights. The Human Rights Act 1998 was passed with the intention of giving effect to the European Convention on Human Rights in the United Kingdom's domestic law. Following the incorporation, judicial review is available in instances where there has been any failure on the part of the public body to respect human rights as stipulated in Section 6, subsection 1 of the Human Rights Act 1998. Section 7, subsection 3 provides that where the proceedings in question are brought on an application for judicial review, a claimant will be regarded as having sufficient interest in the unlawful act if he is or would be a victim of that act. From this, we can conclude that the public interest litigation brought to address the violation of human rights has assumed a much more truncated meaning. As can be seen in Section 7 of the Human Rights Act, it precludes actions by representative bodies, but so on save where they themselves are victims within the meaning of the Article 34 of the ECHR, or where the statute permits such actions. The essential characteristic of a victim, according to case law of the ECHR, is that the impugned act or measure actually or potentially violates his or her rights directly or indirectly. With that said, pressure groups are still able to intervene as third parties, therefore allowing them to make submissions about the interface between national legislative and also administrative choices and the body of case law that have been developed by the European Courts of Human Rights. From this, it is clear that the HRA 1998's limitation on allowing only parties regarded as victims to apply for judicial review has displaced the more liberal approach of interpreting the sufficient interest test. The English court's current interpretation of the sufficient interest standing, which will continue to apply in cases beyond the scope of Section 7, is far more broader, encompassing applicants who clearly will not satisfy the victim test. Recent alternatives can be seen, such as the standing of interest groups who seek to challenge the action of public authorities, even where the case is brought on the basis of arguments concerning individual rights. The position adopted by the courts on this issue will have a very important outcome when it comes to future interest groups' applications for judicial review. However, it is not clear, given the reservation of victims by Section 7, subsection 1, paragraph B, of reliance on a convention right, whether the courts will continue to allow interest groups to make submissions involving the subject matter of convention rights, which will have been recognized independently by the common law. Thus, to sum up this point, the Human Rights Act has simply provided an additional locus standi rule in addition to the sufficient interest test that has already been established. And the determinant factor here of which test will be utilized depends on whether a person is trying to rely on a Human Rights Act or not. This can be said to further add to the ebb and flow of the locus standi rule throughout the years.
Now I will go on to another alternative test, which is a public standing test. So, as a rule derived from the injuries of the victim test, singular candidates may not get to bring an action in the public interest standing, based on the argument that enactment or government practice commonly will in general disregard specific rights. So additionally, while an affiliation may itself be a casualty in certain circumstances, groups have no standing to bring representative applications. These rules preclude interest groups, often regarded as having sufficient interest standing for the English judicial review proceedings, from taking cases to starburst to their own name. So what is public interest standing? Public interest standing includes the implementation of a public right, that is, a privilege given on the general public everywhere, regularly emerging out of legislation requiring public bodies to conduct or oversee exercises relating with general well-being, or in other words, health, security, or the climate. This is as opposed to a private right, which is an advantage presented on an individual or a group. So applying this public interest standing there are 3 steps that a representative from a group needs to go through, where first, there must be a justiciable issue raised as to the legitimacy of legislation. Second, the claimant is influenced by it legitimately or has a certifiable interest regarding the legitimacy or the enactment. And lastly, there are no other effective manner concerning which the issue might be brought before the court. So next to examine is how do judges treat this public interest standing. So along the years, when this alternative test was introduced, judges have made decisions in an extremely strict way, where they see for as long as a speculative individual could bring the case personally, standing isn't sufficient enough to be given. However, based on the recent case, it has developed to be a more purposive methodology, which can be found on account of the AG versus Downtown Eastside Sex Workers United Against Violence. So next, I will be explaining from case to case on how this narrow view approach has become a more purposive approach by the Supreme Court. So this narrow view of standing started to change in 1998 with the landmark case of Friend versus Alberta. So Friend is more commonly known as a decision on the protection of gay and lesbian people from workplace discrimination. The claimant was dismissed from his employment for being gay, and the Alberta human rights legislation intentionally excluded homosexuality as protected from discrimination. Mr. Friend right here made Section 15 subsection 1 of the Charter challenge regarding the Alberta human rights legislation. The province of Alberta argued that he did not have standing dealt with employment. Since the grievance only involved employment, this was the only area where he has standing as of right. So here the Supreme Court of Canada granted Mr. Friend public interest standing to challenge all provisions of the human rights, not just those pertaining to employment but otherwise. So the court rejected a strict reading of the third category because it was inefficient and imposed an unfair burden to unknown potential litigants. So the Supreme Court, on the other hand, recommended the third stage should have been changed, held in the case of Charlie C. Quibby. So in this dissenting judgment of Charlie C. Quibby, Justice Binney noted that while some people may hypothetically exist to bring a case, it is not fair to expect people who are sick and vulnerable to bring wide-reaching systematic court challenges to our healthcare system. Rather than mechanically considering whether a potential private litigant exists, Justice Binney focused on the realistic life experience of potential private interest litigants. So in the case of Morgantler versus New Brunswick, the Court of Appeal picked up on dissenting judgment in Charlie. While obviously other private interest litigants existed, none of them had come forward. Given the intensely personal decision involved in attending an abortion clinic and the cost of timing restraints of charter litigant, it was not reasonable to expect these women to bring the case themselves. So this last case I will be discussing is where the Supreme Court had moved a judgment from a narrow view to a more purposive approach. So this case of AG versus Downtown Eastside Sex Workers United Against Violence. This involves protecting vulnerable sex laborers. They challenge the constitutionality of the criminal code provisions that prohibited bawdy houses, arguing that the prohibition violated the charter because it deprived women from the ability to do their jobs safely. Justice Conway here condemned the idea of traditional public interest standing tests. He proposed a more purposive approach where instead of asking as to whether there is no other sensible advertisement powerful signifies at the third stage, he simply asked whether the current action is a reasonable and effective means to bring the case. So Justice Conwell also provided a list of factors to consider in answering this question, including the plaintiff's capacity to bring the claim, whether it is a public interest case, whether there are realistic alternative means that are more efficient, and lastly, the potential impact the proceedings on the rights of others. So in reformulating the third stage of the test, the court significantly reduced the onus on the prospective public interest litigant and removed a judge's ability to hide behind the hypothetical but unlikely private litigants. This case is likewise significant in the light of the fact that it was the first time the Supreme Court chooses public interest standing as an access to equity issues. Although there are some criticisms upon Justice Cornwell's exception to this public interest standing, nonetheless, the decision constituted a significant step forward in increasing access to charter litigation. It recognizes that public interest litigants are crucial to realizing the charter's democratic potential because they can address the systematic impact of the law on the most vulnerable people in a way that it isn't impossible in individual litigation. The decision paves the way for systematic issues, charter challenges in the future, and it validates the importance of public interest litigation. As such, this standing is a component by which these groups can effectively partake in education of significant social issues. To conclude this standing, there are still room for further development in making this public interest standing more broad, and it has advanced access to the chartered litigation.
Hi, my name is Ling Chen. I'll be further explaining into whether there should be any changes to be made into the sufficient interest test. So what are the problems? So throughout the years, as the question has stated in the case of ex parte Rose Theatre Trust, courts have been very liberal at the interpretation of sufficient interest tests. Compared to a test where personal interest in the matters where the application can relate to is no longer applicable. Subsequently, this will make the test of sufficient interest relatively easier to be applied under. A person with a strong public interest can have standing, even when the claimant has no direct interest in it. The problem of not having a direct interest was shown in the case of R on the application of Maya Evans against Secretary of Defense. In this case, peace activist Maya Evans was granted standing to challenge the Defense Secretary's decision to transfer Afghans who were detained by UK forces during their operation in Afghanistan. Clearly, she was not involved in this, but only as a concerned public member, but was granted standing nonetheless. Similarly to the case of ex parte World Development Movement Limited, where the court gave standing to members who are not directly affected by the overseas grant provided to the government of Malaysia to challenge on the ground of public interest. The wide approach of the sufficient interest test has brought more and more concern as more cases are being brought before the courts to challenge the government decision from parties who have no interest in the outcome. As it can be seen between the year of 2007 and 2011, 50 judicial reviews annually have been applied by NGO, charities, pressure groups, and faith organizations. All these groups are parties who may or may not have interest in the particular matter that may concern them. Hence, it would seem the sufficient interest test that courts have been applying is evolving into something that it wasn't used to be. As from the case of R. Kiddis against South Cambridgeshire District Council, the Court of Appeal laid down the sufficient interest to be a person, and I quote, who, whilst legitimately, perhaps passionately interested in obtaining the relief sought, relies as ground for seeking their relief on matters in which he has no personal interest, in contrast to a person who has interest in the outcome. So now I'll be further explaining into the reason to not amend the test. Contrary to above, sufficient interest test was recommended to be altered into a different test whereby a more direct and tangible interest in the matter will only be applicable for the application for judicial review. The following will be discussing on the reason to not amend the test. Firstly, the test promotes the uphold of rule of law whereby it allows government to act lawfully in their action. How, when they make mistake, courts are the ones who are equipped to rectify the mistake in the way of judicial review. However, courts themselves are not allowed to bring a claim for judicial review. However, courts themselves are not allowed to bring a claim of judicial review themselves. A claimant will be needed to bring such claims. Hence, by amending the test into a more direct test will not allow claimants to bring such challenges as often as they should be when facing those challenges. Courts then will allow the government to do whatever they want, and it may be unlawful without any powers to stop them. Secondly, groups like NGO and pressure groups are technically barred from applying judicial review if a more direct test is applied. Those groups are often representing others who are financially unfortunate who they themselves don't have the funding to bring such matter to the courts. Thirdly, as a court decision in R against Secretary of State for International Development, this case was held during the midst of governmental debate on the subject of reforming judicial review by way of granting standing. Wabi Judge had reached his decision by referring to two other cases, namely AXA General Insurance Limited against HM Advocate and Walton against the Scottish Minister. From these referred cases, he had derived this following principle. A narrow approach to subject judicial review as a means to address individual grievances should be set aside. The principle of sufficient interest is flexible and is contextual. A quote-unquote busybody will not be granted standing, but a claimant also does not have to prove a personal interest if acting in lieu of public interest and be able to show that the issue is directly affecting a section of the public he is representing. In conclusion, the current sufficient interest approach for standing has been working for decades, even though in some eyes it may seem as if the white liberal approach will allow anyone with enough public interest to challenge any decision made by the government branches. But on the other hand, it allows groups as mentioned above to help represent people to let their concern to be heard before court, which allow justice to be sought and ensure government to act lawfully. Thank you.